Hello, everyone. Welcome to Media Law. I know this is a class that for many of you dread taking a little bit because you assume that it's going to be really hard to learn the cases and the law is a frustrating sort of foreign language, and it can be. It can be. Sometimes I think the Supreme Court justices write these cases just as confusingly as possible to try and keep other people away from it. But this class, this is my favorite class to teach because this class is about the greatest fights in American history. The greatest fights, the ones that people are willing to spend years and years fighting and sometimes millions of dollars in legal fees, those fights are the ones that wind up at the US Supreme Court. So imagine the fights that people are so passionate about that they're not willing to just take it to court. They're willing to lose there and then take it to the Court of Appeals and possibly lose there again and then take it all the way to the US Supreme Court, where they have a very slim chance of the US Supreme Court ever taking on their issue. But if they do, great law is made, or some would say great law is made. I guess it depends on your perspective, whether you agree or not. We're going to study a lot of Supreme Court cases and cases from other jurisdictions too. We in Utah we have one federal court, the Federal District Court in Utah. Then we are part of the 10th Circuit Court of Appeals, which is based in Denver. And then, of course, you go to the US Supreme Court. Let me tell you just a little bit about me in case you've not taken a class from me before. Please call me Amanda. I include my maiden name as my middle name, Amanda Dixon Wilhelm, because a lot of people know me by Amanda Dixon. I have been the morning radio host on KSL Radio for 35 years. Long, long time. And I've loved it. But years ago, I graduated with a degree in English from the University of Utah. And then not knowing exactly what I wanted to do with it, not being quite mature enough to become a teacher at that stage in my life, I went to law school. I dropped out of law school and got my first job in radio. Years later, I went back to law school and finished my law degree and practiced for a little less than 3 years. My practice, I clerked for the public defender's office. I clerked later for a civil rights attorney, which was fascinating experience. And we actually worked on one of the cases that we'll be talking about in this class. And then when I graduated and left KSL, I went to work for a firm called Clyde Snow and Swenson. That's what it was called at the time. And we did water law, which I didn't know existed. I was not familiar with the term acre feet of water until I became a lawyer. And then the other half of the firm did a lot of federal criminal defense. So I did some of that too. So I worked there for about 3 years and then I returned to KSL. But now I use my legal education. Well, I use it in a lot of ways. I think I was not a good lawyer. I did not enjoy practicing law, but I loved studying law because studying law is, as I say, it's about studying the most fascinating conflicts in the nation's history. And the way the legal system is set up, it's set up so that, and it's based on the belief that if we bring two parties who both have a vested interest into the court, that each will argue as strongly as he or she can, that they'll bring all the relevant facts to the court's attention, that they'll search for every relevant piece of law. So we need two parties with a vested interest. We can't have people from outside who just feel interested in the issue. You have to have you might have heard the term standing. You have to have standing to come into court. And the legal system is based on the belief that when you have two interested parties like that, they will bring every relevant piece of fact or evidence or law to bear, and the judge will make a decision based on all the available evidence, and that'll be the best decision. It's this confrontational legal system. So my background is in practice, and I'll probably wind up sharing the stories from some of my cases with you. I have a hard time not doing that. And of course, the majority of my background is in media. So I have this sort of strange and unique combination of media and law for my background that makes me love teaching this class. I have to tell you that I really hope that you'll interact with the discussion questions, with questions of your own, because I am happy to post any kind of um, you know responses to your questions as the weeks go on in supplemental lecture videos, because I want this to be as interactive as an entirely digital class can be. Let's talk a little bit about the format of the class. So each week, I will do a lecture that will share slides with you, some other videos with you that I think are instructive of a particular legal point. And during that lecture, I will pose questions. And what you do is you go to the discussion for that week and give as much of a response to those questions as you'd like to give, or share questions of your own, which I am happy to address in future videos. So we'll do that each week. You have 3 exams. They're all on Canvas. They are all closed book. So they are from what you can remember from what we've talked about in class. You are welcome to cite to any case that we talk about in class. If you cite to a case in your exams that we haven't discussed, I'm going to assume you got it from Google and I won't give you points for it. So make sure that you limit the cases that you cite and the things that you refer to what we've talked about in class. So you have 3 exams, and then you have an argument. We'll schedule that a little later in the semester. An argument, you're going to pretend that you're before the Court of Appeals, arguing one side or the other of a case. I've picked a case for this semester. I actually used the same one in the spring. This case is a currently ongoing case. It's based on a case called NetChoice versus Reyes, which is a case that the state of Utah is currently involved in right now. NetChoice is a group that represents a number of social media companies. Meta and a number of other social media companies are part of NetChoice, and they're suing the state of Utah over our law that requires them to age gate some social media platforms, so that they have to have proof of age before they allow a child to be on the platform. And if the person is underage, they're required to do a number of other things, including limiting the functioning of their algorithms and things like that. So they're suing us over that. At the district court level, NetChoice won an injunction against the state of Utah. So that means that they were able to show the district court judge, Judge Shelby, that they would suffer irreparable harm if the case continued, if the law was put into effect, and that they were likely to win. So the injunction pauses the impact of the law at this point. So now the state of Utah is appealing that, and you will argue as if you are the appellate attorney. So one of you will represent the petitioner, who is the state of Utah. One will represent the respondent, who is NetChoice, and you'll argue 2 at a time. And we'll set up separate Zoom calls for that because we'll need to engage during that. I'll ask you a number of questions, and we'll talk about this more when it gets closer. But that's really the format for the semester. You get some points for your discussion questions, the 3 exams, and the argument at the end. Do the readings before you watch the lecture. That way you'll have, if you have questions, you'll know to ask them as part of your discussion question or discussion responses. And I hope you enjoy it, because we're going to talk about all of the super interesting areas of the law. We're going to talk about the First Amendment, of course. That's the basis of all of our freedoms of speech and of the press. We're going to talk about particularly freedom of speech in school. We're going to talk about libel, defamation. We'll talk about the right to privacy and what that means. We'll even talk about NIL contract, name, image, and likeness contracts, which I know have been a big thing in college sports for a while. We will talk about copyright and trademark, and we'll talk about advertising. Some of you might be going into advertising and marketing. There are some relevant case law around that area that we'll discuss. And We'll talk about the telecommunication regulations at the end of the semester, which is sort of a dry one. Except for that, it involves some very spicy cases, like the wardrobe malfunction case with Janet Jackson at the Super Bowl many years ago. That case is one of the FCC cases that we'll discuss. There are some of these cases are not going to be hard to remember. I mean, there's one case that we'll talk about this semester, and it's called, I'm not kidding, the Bong Hits for Jesus case. That's the way we refer to the case because it involves a kid who was standing across the street from his school holding up a sign that said Bong Hits for Jesus. And the question that we'll talk about when we talk about that class is was that speech protected by the First Amendment, or could the school could they reprimand him for holding up a sign that talked about Bong Hits and Jesus across the street? So what I'd really like you to do at the beginning of this week's discussion questions is I'd like you to introduce yourself so we know who else is in class. So start by doing that in any way you want. You can share a picture, you can share a story, just tell us a little bit about where you are in school. I know you're majoring in some area of communication. You can tell us more about that if you like. Anything that you'd like to share to help us get to know each other a little bit so that maybe I can tailor some of future discussions to you directly, and your fellow students can get to know you too in case you want to share or contact each other back and forth for any reason. So start there with an introduction to yourself. Okay, let me see now. Okay, I'm going to share my screen here with you. Let's see if I can bring that up so that we can go through the first lecture. Okay. All right. We're going to get a real basis for the law today. I'm just going to sort of share with you the basic legal concepts that will let us talk about the First Amendment cases coming up. So there are 5 different sources for the law. And I'll explain what I mean by that. Have you ever heard the phrase common law? Common law refers to law that comes from cases, comes from a court. These are opinions written by judges that create the law. So every time 2 parties come before the judge and they fight over something, the judge will make a ruling bringing their unique set of circumstances to bear and looking back at previous cases and deciding and then writing an opinion. And then that case becomes part of the common law. The common law is, I guess you could call it judge-made law because it's decided as they go for each case. This is the common law. And they refer to it that way as opposed to ecclesiastical law. So ecclesiastical originally, you think way back when, when there was a dispute between people, they would go to the religious leader, and the ecclesiastical or religious leader would be the one who would resolve the dispute. When that became more of a secular exercise and the church wasn't the one resolving disputes, then they went to a local magistrate or local judge who would be over a certain amount of geographical area. And they would bring their disputes and that judge would make a ruling. So they called that the common as opposed to ecclesiastical law. Equity law is now when you are bringing a case in equity, as they say, you're doing that in the exact same court that you would a case at law. The courts used to be separated. So if you were bringing a case at law, you'd go to one court, in equity to another court. All that it means to bring a case in equity is that you're not looking for money damages. You're looking for a different kind of remedy, an equitable remedy. An injunction is considered an equitable remedy. So if you're coming to court because you want to stop another party from doing something, money is not going to compensate you for that. It's going to take actually stopping them, a court order to stop them. That kind of an injunction is considered an equitable remedy. So that's why we sometimes think of the equity law and common law as separate categories. Statutory law is, I'm sure most of you know, these are statutes. They come from legislatures, either state legislatures or in some ways, even a city council that passed an ordinance would be a form of statutory law. And of course, Congress passes laws, statutory law. These are all available for everyone to see. And they are amended many, many times, but this is why they say, your ignorance is no defense, because statutory law is available for everyone to see, and we all have notice of what is in the statutory law. Constitutional law, both federal and state, is the founding law. So any other law that's made after the constitutions, whether it's statutory laws, or statutes or laws that are passed, whether it's decisions from a court, the common law, has to pass muster with the founding documents, the Constitution of the state of Utah, of the United States. Those are the basic documents that are the foundation of all legal authority. So if a law that's passed by Congress or the state legislature conflicts with some constitutional provision, they'll find that law to be unconstitutional, and they'll void that law. So it's sort of the mother of all documents, the federal and state constitution. Executive orders and administrative rules. You've probably heard about executive orders recently. This is in the news a lot because not just President Trump, all presidents pass executive orders, but they use their executive authority as the chief executive of the federal government, or in the case of the state, it would be the governor there are a number of things they can do without their legislatures, that they can exercise authority that affects a number of areas. If a party thinks they've exceeded their authority, they can sue. So they'd sue the executive and say, he has exceeded his authority, try to take him to court to say that what he's done is unconstitutional. So that's one of the ways you challenge an executive order. Administrative rules, of course, come from the many agencies in the federal or state. All of these things mirror the federal government, the state government. So in the federal government, it's all the ones that you can think of, the FCC and the FDA and the FTC. There's a million of these federal agencies, but they exist for a reason. And that area of law, administrative areas of law, is more complicated, but we'll talk about that. Let me save that for a future slide. Okay, so the common law or judge-made law, we did inherit this procedure, this process from England, that they had magistrates set up around the kingdom who would address disputes among citizens. And we likewise had magistrates here in the colonies when we were first formed that would look at these cases, sometimes called judge-made law. Oh, here we get to the concept of stare decisis. Stare decisis, which is a Latin term used in the law that means let the decision stand. Stare decisis is a very important concept because even though each case that comes before a judge is coming for the first time, presumably before the judge is not making a decision on that case with no guidance. That judge is not saying, well, I think this is right. That judge has to look at other similar cases that were decided in its sort of chain of command. So at its state supreme level or the federal court level or ultimately the US Supreme Court level, and follow those decisions. I was going to share with you, there was a quote from the current Chief Justice of the US Supreme Court, is Chief Justice John Roberts. Here's what he said about stare decisis. Stare decisis is grounded in a basic humility that recognizes today's legal issues are often not so different from the questions of yesterday, and that we are not the first ones to try to answer them. So it's the concept that says you follow precedent. The thing about the common law that makes it uniquely strong is that it can change. It can adapt to all of the myriad ways that we as a society have changed over the centuries, right? Since the initial courts were founded in this country, we've changed in such profound ways. We continue to change. And the common law will look anew at each set of facts and try to bring the right precedent to bear to help mold the law. So it can be flexible. Statutes, unless they're amended, are not terribly flexible. The Constitution is the most inflexible for a reason. You don't want the Constitution to be something that can be ever changing. You want it to be a great base or bedrock for the law, so it's very difficult to change, but the common law can change with each case. All right, so you have a precedent. You have a previous case that is in your area. So one of the things I did a lot when I was a lawyer was I'd have a partner come to me and say, I want to argue this. Go find me a case so I can argue this. And I would go back then into the law library because we didn't have access to the internet. And I would research and read sometimes hundreds of cases, looking for a case that was sort of like ours. And there was a cross-referencing, system. So I wasn't just, blindly reading cases, but I'd be looking for a case that had the law I needed it to, that said the thing I needed it to say, that had facts that were similar to my facts, so that my partner could go before the judge and say, as the court said in blah, 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 they decided this, and likewise, Your Honor, you should do the same. So there are different ways that we can deal with precedent. We can accept or follow the precedent. If the precedent goes our way, then we're going to argue for the court to follow the precedent. So sometimes a court will cite a previous case, and that's the reason for their holding, and they become another in this sort of strong chain of law that goes back to other cases that upheld previous precedents. A case can modify or update a precedent by saying, this precedent holds, but under current circumstances, we need to modify it slightly to accommodate current circumstances. Here's that flexibility in the common law. So particularly the US Supreme Court. The US Supreme Court can do anything it wants. Lower courts have to really make a case for why they are deviating from a Supreme Court precedent. And if they screw it up, it's possible that they'll get appealed up to the US Supreme Court. So accept or follow, modify or update. You can distinguish here. So let's say, for instance, there's a case that is totally against the argument you want to make for your client. You've got to find a way to distinguish that case. And by that, I mean, you've got to find a way to say to the judge, Your Honor, yes, I will admit that the court held in X versus Y exactly the opposite of what I'm asking you to hold here. But had the facts and circumstances been the same as they are now in X versus Y, the court would not have held that way. The facts and circumstances are so profoundly different that you cannot compare and apply the law from X versus Y to what's going on here. So you're going to distinguish that case. You're not suggesting it be overruled. You're saying that the facts are different enough in this case that precedent should not be compelling, that another precedent should be, it's more like this than it is like the one that's against you. And of course, there's overrule. A court, well, first of all, the US Supreme Court is the only court that can overrule its own precedents. A state Supreme Court can overrule its precedents, but not the US Supreme Court. So the US Supreme Court is the ultimate arbiter of all things under federal law. The state Supreme Court, though, is the ultimate decider of its own constitution. So the Utah State Supreme Court is the court that can make the final decision on how to interpret and apply the Utah State Constitution. So when do you overrule a previous decision? When facts and circumstances change, when social mores change sufficiently. Sometimes people would argue when the judges change, when the court itself changes, and that has a lot to do with it because you need a majority of judges to overrule previous precedent. And if the judges who lean one way or the other, if that makeup changes, you are more likely to overrule a precedent. For example, in Lawrence v. Texas was a case that held that you could not make homosexual sex a crime in any state in the country. It used to be, some of you may not have known, a crime in almost every state. And slowly states took that off their books, but Texas held on to it. It overruled Bowers v. Hardwick in that decision because Bowers v. Hardwick actually had upheld a state law that said that the states can decide whether or not a homosexual sex is a crime. So in Lawrence v. Texas, they finally overruled that and said, no, no, this is something that is not a states' rights issue. States don't get to make up their own minds about this, that it is a violation of equal protection of the law to treat adult homosexuals who are having consensual sex any differently than we would adult heterosexuals. So they overturned that previous precedent. Why? Because mores changed, because society changed, and likely because the makeup of the court was such that they were amenable to changing that. Now we get to another example, but in what some would call the opposite direction, which is Dobbs v. Jackson. Dobbs v. Jackson is the case a couple of years ago that overturned Roe v. Wade. So Roe v. Wade, of course, established the right to abortion under certain circumstances in the United States 50 years ago. And Dobbs v. Jackson is in large case a response of the court itself changing, that enough members of the court wanted to overrule Roe v. Wade that they got in the majority and were able to do that. They cited, original discussions around the founding of the Constitution and how abortion was illegal in the 1700s. And therefore, since there was no right to abortion at the time when these amendments were enacted, that we can't infer a right to privacy or a right to abortion as part of a right to privacy from that document. This is a complicated legal argument. We can talk more about it later in the semester, but those are the kinds of, original intent kinds of arguments of what were the founding fathers thinking when they wrote the original Constitution or they passed the Bill of Rights, that you can go back to their there are documents of their discussions when they were talking about the passing of these, as you can go to the legislative notes on the passing of any number of laws today and try and get more information to argue what they were actually thinking. So we go beyond the words of the laws themselves or of the Constitution itself to sometimes argue what they were thinking. Okay, so that's common law. Let's talk about equity law. So with equity law, money is not the goal. People are seeking some kind of an equitable remedy, which is, as I mentioned before, an injunction, can be a restraining order. Here is an example of a case where this is John Bolton, who was a national security advisor for President Trump in his first administration. And after he served in that role, he wrote a tell-all book. Let's just watch this for a second.
The Department of Justice is now seeking an emergency order to block the publication of former National Security Advisor John Bolton's upcoming book. In the Room Where It Happened, a White House memoir is expected to be released Tuesday. According to the New York Times, which received an advanced copy of the manuscript, part of Bolton's book focuses on the House's impeachment inquiry into President Trump. Bolton reportedly writes the House's probe was too narrowly focused on the president's dealings with Ukraine, and instead it should have looked into other times President Trump tried to further his political interests. Bolton writes that one of those times reportedly occurred when President Trump stated willingness to interfere in criminal investigations into big companies in China and Turkey as, quote, personal favors to dictators he liked. In an excerpt published by the Wall Street Journal, Bolton writes, had Democratic impeachment advocates not been so obsessed with their Ukraine blitzkrieg in 2019, had they taken the time to inquire more systematically about Trump's behavior across his entire foreign policy, the impeachment outcome might well have been different. The DOJ's emergency order move comes after the Trump administration already filed a lawsuit against Bolton. The lawsuit argues Bolton's manuscript is filled with classified information and that he didn't finish a contractually obligated review process with the White House. President Trump criticized Bolton on Twitter Wednesday night, calling him a disgruntled, boring fool whose book is made up of lies and fake stories.
So why does that sun is coming in a way that's sort of awkward there. My apologies. So why is the Trump administration seeking an equitable remedy? Because money is not what they're after here. They're not asking for the proceeds of the book. They want to stop the book from being published because they claim some of the material that is shared is classified. But the judge refused their request for an injunction because here's one of the things about injunctions. Not only do you have to show that there's an irreparable injury and that you're likely to win, But you have to show that the injunction will actually be effective. You have to show that if the injunction is granted, it will stop the information from getting out. But the books had already been shipped. The books had already been shipped to bookstores all over the world. And so the court said, basically, you can't put that toothpaste back in the tube. And so since the injunction would not be effective, they refused to grant the injunction. That's United States versus Bolton. All right, let's talk about statutory law. So statutory law enacted by state legislatures or Congress deals with all of society, large groups. So in these cases, you're not having one party coming to argue against another party. You're not resolving a specific dispute. You're passing a law that will have equal effect on everyone in society. So it deals with much larger groups. A statutory law can anticipate a problem. So maybe they see there's a drug problem, or there's going to be a drought, there's a water problem. So we're going to pass a law that requires people to behave differently with the way they use water, because we're anticipating that that drought is going to be severe and have a negative impact. Or we see a need in education, we're going to pass a law that has an effect on that. The statutes can address these future large problems, but a common law cannot. A judge-made law is limited. They cannot issue advisory opinions. They can't share thoughts on an issue that have the impact of law. They have to wait until two parties who are fighting come before them, and then they can address that. Criminal laws are all statutory. Why do you think criminal laws are all statutory? Go ahead and write something about that in your discussion questions. Why are criminal laws all statutory? Why is it not okay to have those be case by case as part of the common law? I'll let you comment on that. And of course, statutes are found in all of the codes and law books, and now online, that you'll find. This requirement that common law or judge-made law be based on a real case in controversy came up recently in a big case before the US Supreme Court called 303 Creative. Let me share a little bit of this with you.
The Supreme Court closed out its term this week, delivering 3 decisions that will change the course of American society. And in all 3 cases, the court was split 6-3, further highlighting the intense ideological divide between the 9 justices currently serving on the bench. One of those cases concerns a Christian web designer named Lorie Smith, who was planning to one day, maybe, perhaps, I don't know, possibly, open up her business to designing wedding websites. Let's be clear, she had not done so yet. But when she someday makes those hypothetical wedding websites, she wants the right to refuse service to gay couples on the religious grounds. In her case to the Supreme Court, she cited one example of a potential client, a man named Stewart, who was requesting a wedding site for himself and someone named Mike. Smith's lawyers allege Stewart's request came just one day after she filed her initial suit back in 2016. And on Friday, the Supreme Court sided with Smith. Here's where the story takes an odd turn. This past week, as the Supreme Court was deciding the case, reporter Melissa Jarrett Grant with the New Republic gave Stewart a call to confirm his side of the story. It turns out Melissa's call was the very first time Stewart had heard of the case or Lorie Smith. In fact, Stewart is already married to a woman. Stewart told Melissa, quote, "I wouldn't want anybody to make a wedding website. I'm married. I have a child. I'm not really sure where that came from, but somebody's using false information in a Supreme Court filing document." So this case was based purely on the imagination of a would-be Christian web designer.
This is such a bizarre twist to this case, which we'll talk about later in the semester, because 303 Creative, as they mentioned, deals with this woman who didn't want to make a gay wedding website. And so her refusing service to that gay couple triggered the laws of the state that prohibit discrimination. So you can't discriminate based on people's age, ethnicity, gender, sexual orientation. You can't discriminate. So the anti-discrimination law was triggered. But she argued all the way to the US Supreme Court that the anti-discrimination law was infringing on her First Amendment rights and that she was being compelled to speak. This was compelled speech, she argued, and that was unconstitutional. We'll talk more about the actual holding of the case when we get to that section. But for right now, the thing that's interesting is that if it's true that that case, that she was never actually asked by a real gay couple to do a wedding website for them, then she did not have a vested interest in trying to overturn the law. And remember the ruling that you must have a real case and controversy, that when you come before the court, you have to be a party who is directly affected. And how this wasn't uncovered until a reporter uncovered it after the fact, I do not know. That feels like something that would have been discovered earlier on. But that case, that case is questionable in my mind because it perhaps violates that foundational standing rule that that party didn't have standing. All right. So when we're looking at statutes or the Constitution, this is called statutory construction. We're studying what the thought process was. What was the legislative intent? What were they thinking when they used that word? What were they thinking? So if you are attacking a statute, if you're trying to argue that a statute should be voided or not enforced in your case, you can attack it in one of two ways. You can attack it on its face. You can say that the whole statute is unconstitutional. The whole thing should be voided. So that two different ways to attack that on its face is to say that sorry, my dog is here. I'll let you see my dog. See, hello, Molly. How are you? It's void for vagueness. That's one way of arguing. And that's something that I'll give you examples of cases where the law is written in a way that's vague enough that you can't enforce it on a consistent basis. So that's an unconstitutional law that's void for vagueness. Or the law is overbroad. Maybe the law is trying to address a specific problem, but it attacks a whole bunch of speech that isn't necessary. So it's overbroad. It needs to be more narrowly tailored. That's if you're attacking the law on its face. You can also attack the law as applied, which argues that the law itself, pardon me, sneeze, excuse me. Good golly. Pardon me. Oh, we're going to get through this lesson. All right. So if you're arguing as applied, you're arguing that the law itself is constitutional. The law shouldn't be struck down in total, but as it's applied to this set of facts, it's unconstitutional. So it's being applied in a way that is unconstitutional. Sometimes that can be a situation where a person in government has too much discretion. So the law itself might not be suspect, but the way they're applying it is maybe based on the person's speech or some other, we'll talk about a case that had to do with a drag show in St. George, where they wanted a permit to hold a drag queen story hour kind of event. And they were denied the permit when other people were granted the permit to have similar events in that same space. So the court, in that case, it wasn't that the permitting law was unconstitutional on its face, but as it was applied, it allowed for too much discretion. And so it became unconstitutional. But we'll get to that later in the semester. Okay, so we get to constitutional law, which is the supreme law of the land. We have three levels of what are, in essence, constitutions. We have the federal constitution, the Utah state, and every other state has a constitution. City charters are really a version of this, which create the authority of city councils, mayor's offices, and various organizations in that smaller governmental entity. So they provide for the establishment and organization. They outline the duties and the powers of various elements of the government, and they usually guarantee certain basic rights to the people, at least in our liberal form of democracy. And I use the word liberal not to mean democratic or of the left, people who are leaning left. I use liberal in the original understanding of that word, which is that it protected basic human rights. So there are democracies in many parts of the world that are not liberal democracies. They are based in some way on the vote of the people, but individual rights are not protected. So that kind of democracy looks very different. If you have a country where you have an election, but if you don't vote for the main guy, your family gets hurt, or they lose their jobs, or you get put in prison. Is the result of that is the result of that election a democratic result? Well, it's the vote of the people, but that's not a liberal democracy because civil rights and individual rights are not protected. All right. Yes, you can change the Constitution. It's very difficult to do. It has to be proposed by either 2/3 of the House and the Senate or 2/3 of state legislatures. And then, if you can get that huge number to propose the amendment, then you have to get approval from 3/4 of all state legislatures or all constitutional conventions. So, for instance, I know right now you've heard President Trump joke about running for a third term as president, which is prohibited under, I think it's the 22nd Amendment to the Constitution. If he wanted to seek a third term, he would need to change the Constitution to change the writing of the 22nd Amendment or to, in some other way, affect that change. That would require 2/3 of the House and Senate and then 3/4 of all state legislatures. So it would be very, very difficult to do. All right. Let me just pause for 1 second. I will be right back if I can find this here. Pause. Okay, let's see. Let's go back to the screen where we were. These are all of the current amendments to the US Constitution. So there is Amendment 22, two-term limit for a president. Of course, the original or the first 10 are considered the Bill of Rights, 1 through 10. This is sort of a funny thing, but the First Amendment, which includes speech, press, religion, and assembly, so some of the big ones, some people will refer to it as the most important amendment, and that's why it's first. But originally, this is where you go back and study legislative intent and how the people who were at that original Congress discussed these amendments. It was not the First Amendment. It was the Third Amendment. The first and the second didn't pass. So the third became the first. The first and the second were about, one of them had to do with salaries. I think one had to do with taxes. So they weren't arguably as important, but it wasn't the first proposed amendment. It was the third. So there are all the different amendments. We'll deal mostly with the First Amendment. All right. So a statute is void for vagueness if you can't tell which speech is allowed and which speech is prohibited. So remember, a statute applies to everyone, and criminal statutes apply to everyone. You need to have notice that your conduct is going to be conduct that is prohibited in some way by law. So if you don't have notice, it's going to be void for vagueness. And if it allows too much discretion, like the example I was giving you of the drag show in St. George, if it can be enforced unfairly, they've given too much discretion to police or magistrates, and that's going to be void for vagueness as well. The overbreadth doctrine says that the law is unconstitutional because it's overbroad. It's aimed not just at the problem that it supposedly exists to address, but it also incorporates all this other area, other speech that should not be blocked is blocked. So it's overbroad. An example of that is this funny case of Washington versus Immelt, which they had an ordinance that said that honking of a horn for any purpose other than public safety was against the law. So this woman she was so mad at her neighbors, she would go outside their house. Was it at a specific time of day? Hold on, let me check this. This to make sure. It's early in the morning, just early in the morning. So she goes outside of her neighbor's house and honks repeatedly early in the morning. And the court said, conduct such as honking may rise to the level of speech when the actor intends to communicate a message. So that's a form of symbolic speech. So you don't think of a horn as speech, but anything that communicates a message. There's an actor, there's an audience, and there's the intent to communicate a message. And certainly she was communicating a message. That is a form of symbolic speech, which will be covered by the First Amendment. Okay. So, yeah, let's talk a little bit about administrative agencies. Now, we'll deal mostly in this class with the FTC and the FCC. But I want you to understand the background of why these agencies were created. And many of you may already know this, but so consider this a review. So in the early days of the government, if American citizens had any kind of a beef with each other, whether it was a criminal law situation, a state's criminal law being imposed on a citizen, or two citizens were fighting over property or anything, they took it to Congress or they took it to the president. As the population grew, that became impossible. There were just too many people who were seeking redress. And so Congress decided, this comes from Congress, they decided to create these agencies who had areas of specific knowledge and expertise. So HHS, Health and Human Services, Health and Human Services, or the Food and Drug Administration, or the Federal Trade Commission, Housing and Urban Development, that's HUD, NASA. So, they created these agencies with people who had very specific areas of knowledge. Because first of all, Congress can't know a very deep level of knowledge about all subjects. Most people can't. I think of my own knowledge as I'm an inch deep and a mile wide on a lot of topics. As a journalist, that's what I have to be to interview people. But Congress wanted these agencies to have people who were very deep in their knowledge in limited areas. So that because it's not if, it's when people in the country are going to have issues with the environment or with the criminal laws or the budget or whatever else, that they would go to that agency and seek redress there. Now, we'll talk about this more when we discuss it, but there are levels of how you can appeal from decisions from administrative agencies. But this is why these structures were created. Have they gotten over bloated? Perhaps. I think there's probably waste in all entities, government, non-government, private sector. There's probably waste that can be removed. And certainly we're watching these agencies be pared way down right now. All right, so if something happens at the administrative agency level, you can seek to have that overturned by a court when the original act that created the agency is unconstitutional. So that's sort of a broad way of attacking it. Let's say you go before the FCC, you're being denied a broadcast license or something like that. You can go to court and say, the FCC was acting outside of the charter for which it was created. That's also number two, it exceeds its authority. Here's an example of that. So I don't mean to confuse those two. So the original act is unconstitutional. That's one argument. The agency exceeds its authority is a second argument. Biden v. Nebraska had to do with the Department of Education's forgiving student loans. Let's hear just a little bit of the oral argument in that case.
Justice Thomas, anything further?
Just briefly, there's some discussion in the briefs that going past with this provision or that modification or waiver, that this is in effect a cancellation of a debt. That's really what we're talking about. and that as the cancellation of $400 billion in debt, in effect, this is a grant of $400 billion, and it runs headlong into Congress's appropriations authority. And I'd like to give you some time to respond to that.
Sure. And so first, I want to take on the argument that some of me.
That was Justice Clarence Thomas. You know, what's interesting about that is that for the longest time, Justice Thomas never asked a question from the bench. I don't know why, but for years, maybe decades, he never asked a question during oral argument. And then during COVID, they started having the arguments electronically. And when the first time he asked a question, I just about fell off my seat. I thought, Justice Thomas is asking a question? What in the world? So that's Justice Thomas asking. The woman who's answering now, her role is called Solicitor General. She is arguing on behalf of the United States. So she's defending the action by the Department of Education.
He have made in this case about implicating appropriations authority. Of course, implementing this program doesn't require that any money be drawn from the Treasury. And so I don't think that it strictly raises an appropriations issue, which is why I think the states aren't raising that argument here. And to the extent that the concern is about the secretary taking action in a way that Congress didn't authorize, it seems to me that it just collapses back into the central interpretive question in this case, which is, does the HEROES Act authorize the secretary's action or not?
So I won't get any more into that, but this was an interesting argument that, and ultimately the court held that in forgiving those student loans, that the Secretary of the Department of Education was exceeding the authority granted by Congress to them. So the agency did exceed its authority in that case. If the agency violates its own rules, it may have rules, like, for instance, later in the semester, we'll talk about the rules on expletives on the air. You know, if somebody drops an F-bomb by accident during a live broadcast, the agency had the rule that a fleeting violation of the rule would not be subject to fines. That's their own rule. So if they violate that rule, you can argue that. Or the sort of catch-all argument against administrative action is there's no evidentiary basis whatsoever to support the rule. Sort of a big, broad argument there. Okay, let's talk a little bit about the way the judicial system is set up. At the trial court level, that's where facts are established. Certainly you argue law there, but you put on evidence. You have testimony, you share physical evidence if there is any, you share expert testimony to interpret the facts. If you're looking at the trial court, this is where facts are determined. Facts are not determined at the appellate level. Law is determined at the appellate level. So the facts are determined, and then the jury decides whether those facts meet the law as explained by the judge. If you lose at the trial court level, then you appeal, usually to a court of appeals. You don't go straight to the Supreme Court, although that's not unheard of. So when you appeal, now the argument is the law was applied incorrectly to the facts. So you can't put on new testimony at the appellate level. You can't present new evidence, except in rare cases. Largely, you're arguing that there was a mistake of law at the trial court level, and that's what you're arguing on appeal. All right. So in the federal courts, the Congress establishes the federal courts. There is no obligation that they establish any certain number, at least not in the Constitution. So for instance, it is based largely on a population, but in the state of Utah, we have just one federal district court because, at least so far, our population hasn't warranted a second one, although that may change. So when does the federal court have jurisdiction? Here's a long laundry list of areas where, because normally you have to decide, do I bring my case in state court or do I bring it in federal court? If the case arises under the US Constitution, law, or treaties, that's called federal question jurisdiction. There is a question of federal law, and if that's true, then you can bring it in federal court. If it involves ambassadors or ministers, if it involves admiralty or maritime law, so anything that happens in the oceans or seas around the country, if it involves the United States as a party, so all federal criminal cases are US versus, that comes in the federal system. If the controversy involves two or more states, if, for instance, we were suing the state of Nevada or Colorado over water usage from the Colorado River, that's going to be in federal court. You wouldn't let these state courts in Utah handle that. That'd sort of be like letting the home team decide. So they try and remove it to federal court. Controversies between a state and a citizen of another state. So the state of Utah is suing a citizen of Nevada, that's in federal court. And then the most common one is called diversity jurisdiction. And that is a case between citizens of different states if there's more than $75,000 at stake. So the federal court will not hear the case if it's a small sort of issue. If it's a fender bender and there's $10,000 of damage, the court's not interested. But if it's a large enough issue between citizens of different states, then you can get diversity jurisdiction and be in federal court. All right, so the Supreme Court only has original jurisdiction, which means the case starts there in very rare circumstances. I've heard of one circumstance, and I think it involved the state of Utah, and it was over water. But usually you do not start at the Supreme Court. They are not a fact-finding court. You get there last. So do they have original jurisdiction? In limited areas, but usually you don't use that. You go there on appeal. So it's an appellate situation. There are two ways to appeal to the US Supreme Court. One is on direct appeal, which is it's a federal question. You lose at the trial court level. Let's say you go to the 10th Circuit in our case, you lose there. You want to appeal to the Supreme Court. You have a right to appeal. But I say that with quotes because 9 times out of 10, the court is not going to take the case. And the way they get around taking the case is that they say there is want of a substantial federal question. That is their fancy way of saying nobody cares. There's not an issue for us to resolve here. You lost, and we would let you lose too. So they will just not take the case. And when they don't take the case, then the lower court ruling stands. The petition for a writ of certiorari is a different situation. It involves the request to have the court take the case. There's no direct right to an appeal, but usually people will seek a writ of certiorari if the circuit courts are disagreeing about a particular issue. So you might have the Fifth Circuit ruling one way and the Ninth Circuit ruling another way, and we need an answer as to what the law is, because people in different parts of the country are functioning under different rules, and we can't allow that to continue. So that's when you have a better chance of getting before the US Supreme Court. But there's this thing called the Rule of Four. And the Rule of Four says, here's what happens when an appeal or a writ, request for a writ goes before the US Supreme Court. The clerks for all the justices read all of the cases, and then they brief the justice on the case, and then the justice will decide whether or not he or she wants to take the case. They go into a conference, and in that conference, they vote on whether or not to take the case. The vote starts with the most junior justice. So the newest justice to the court, who right now would be Justice Amy Coney Barrett, she votes first. And then it goes by seniority, getting up to the chief. And if 4 justices decide they want to hear the case, they take the case. That's the Rule of Four. They can't get 4 justices to want to take the case. They don't take the case, the lower court ruling stands. It's sort of a difficult thing, I think, for many people to understand, myself included, that the main focus of the US Supreme Court is not to make sure justice has been served. That, I know, is a very difficult thing for many people to accept. How can justice not be the focus of the US Supreme Court? But it's not. The way that Justice Roberts has explained it, and others before him, is that their primary function is the development of the law. They have to make sure that the law progresses and develops in an orderly way. So for instance, when the court took on Brown versus Board of Education and finally held that people of color in this country were entitled to the same quality of education as white people were, the court could have ruled that way years before, when they ruled that separate but equal did not violate the Constitution. It took a changing of the justices, it took a changing of the mores, and it took a belief by the court that the country was ready for the change that they wanted to implement. So similarly, that you could look at the gay marriage cases. Could the court have ruled that gay marriage was a constitutionally protected right under the Equal Protection Clause, that gays in this country had a right every bit as protected as heterosexual people? They could have ruled that decades before they did. There were cases that tried to go up decades before, but they didn't get there. And arguably, the reason they didn't get there is that they waited until they believed a significant portion of the country could accept a ruling like that. So it's a strange thing, but justice is not the court's primary focus. All right, let's go back here and talk a little bit about amicus curiae, or what they call in plural form amici briefs. Amici briefs are friends of the court briefs. We in the state of Utah file friends of the court briefs. Individuals can file friends of the court briefs. The Church of Jesus Christ of Latter-day Saints files many friend of the court briefs. These are briefs from interested parties that they file with the Supreme Court to complement one side or the other in a case that's before the court. So, for instance, a Obergefell case, which was the gay marriage case, there were like 200 plus amici briefs from religions and interested groups and people, and even people in other parts of the world that want to call the court's attention to something that's of particular interest. Here is an important point that I want you to think about. The courts have no enforcement arm themselves. So what happens if a court makes a decision? Who enforces that decision if the people don't want to obey the decision? Let's say, for instance, in Brown versus Board of Education, when the court held that schools must admit Black students to their ranks, the court can't enforce. It takes the administrative arm. So you remember the stories of how they had to send federal marshals down to Alabama and Mississippi and some of these states to be there at the school to allow the Black children to attend school, because the local arm of enforcement, the state police in those states, they could have cared less. They had no intention of obeying the law. This is going to get sticky. And the power that courts have is in our respect for their decisions. The democracy functions on our obeying the decisions of the US Supreme Court. We might not like them, but if we don't like them, we try and find another way, a legislative way around it, or electing someone else, excuse me, to the executive branch. We go about trying to fight against a decision in a legal way. Many, many people in this country were furious with the Dobbs decision overruling Roe v. Wade, but they are upholding the decision in states where that's been forbidden. Doctors are not performing abortions in those states. I'm sure that there are a few people breaking the law, but in large measure, the law is upheld. What happens if a president refused to obey the decision of the Supreme Court? It's never happened before. We ask that question now because we wonder, is it possible that the Supreme Court would rule against President Trump? And if he didn't want to obey the Supreme Court, how could you enforce that? The court has no army of its own. The enforcement arm is the executive arm. So this question came up during the Nixon administration, because when Nixon refused to turn over the tapes, that led to the whole Watergate scandal and his being forced to resign, what if he had just refused? There is this tension that has always been resolved in favor of respect for the court system, but we are living in interesting times. All right, so the types of opinions from the U.S. Supreme Court. Just checking my notes to make sure I've covered everything I want to there. All right. All right, so the majority opinion, if the opinion is not unanimous, it's not 9-0, or even 8-0 if somebody recuses themselves from the decision, the majority opinion would be a 5-4, 6-3. Anything more than 4 is the majority opinion. A concurring opinion, you'll often see that. If a justice agrees with the result of the majority opinion, the justice may want to say something on her own or his own. They may agree with the result, but not the reasoning exactly. So they want to have their 2 cents. And they think it's important enough that they don't just sign on to the majority opinion, they write their own opinion. That's called a concurring opinion. A dissenting opinion, obviously, they disagree with the majority opinion, and here's why. That's a dissenting opinion. A plurality opinion it's not a majority because it's not more than 4, but it's the largest number. So let's say, for instance, you have 4 people voting one way, 3 people concurring, there's 7. That's the majority now, and 2 people dissenting. There's not one opinion that's 5, but this 4 opinion would be the largest number signed onto. It's called the plurality opinion. A per curiam opinion is a sort of interesting opinion. In some very controversial cases, no justice will own that they wrote it. It'll just say per curiam from the bench, from the court. It's an unsigned opinion. And it's not it is sort of it's a way of handing down a decision without it being attributed to a specific justice. The most unsatisfying of decisions to get from the U.S. Supreme Court is the memorandum order. So, how long does it take to get to the U.S. Supreme Court? If you get there at all. So think about it. And they get, 8,000 petitions for certiorari every year, 8,000 average, maybe more than that now. And they take maybe 70 cases. I could be off on those numbers a little bit, but that's on average. So your chances are very slim. So let's say you've been fighting for years and you file your petition. It might, the whole process could be 5 to 7, maybe 8 years. You get all the way to the US Supreme Court. And the only thing you get is a memorandum order that just announces the vote. Upheld 5-4, upheld 6-3, upheld. They say nothing. So there's no guidance in the law. They're just upholding the lower court's ruling, or they're reversing and remanding. They're reversing the court's ruling and remanding for further proceedings. I can't imagine what it would be like to fight like that and work that hard for that many years and have basically just a stamp that says denied. That would be crazy. Okay, so let's talk about the lower federal courts for a second. There are 94 district courts, including that one here in Utah. There are 13 circuit courts. The reason they call them circuit courts is that back in the day, the justices of the U.S. Supreme Court went out into the country, territories before there were all the states. Excuse me. And they rode the circuit. That's what it was called, when they would go out into the territories and hear appeals in various parts of the country. They'd be riding the circuit. So now there are 13 circuits. 11 of them are numbered. And then there's the DC circuit, which handles all of the administrative agency appeals in the District of Columbia. So it's a very busy circuit court of appeals. And then there's what's called the Federal District Court, which is limited in subject matter. It handles all patent cases and other things that require a specialty. In the law, there really isn't a recognized specialty. Certainly lawyers they do specialize in areas. So you'll have a water law attorney or a criminal law attorney or a bankruptcy law attorney. But the only one you're allowed to claim legally is patent law. There's actually a separate patent portion of the bar exam that I did not take myself because I had no interest in practicing in that area. But if you're going to go into that area, you have to take a special portion of the bar exam. So that puts you in this sort of unique area of the law that is only known to patent attorneys by and large. So in the circuit court level, if you appeal from the district court, you're usually going to get a 3-judge panel. A random 3 judges from that circuit court will be assigned to your case, and you'll argue before them. If you lose before that 3-judge panel at the circuit court level, you can either appeal directly to the Supreme Court, or you can ask for what's called an en banc hearing. An en banc hearing, and on the bench. You want the whole circuit court to hear it. Rarely granted. But if you think that 3-judge panel is not representative of the circuit court as a whole, you can ask for the whole circuit court to hear your case. And that would be another step in the appeal process on your way to the US Supreme Court. So judges, federal court judges, federal appellate court judges, and US Supreme Court judges are all appointed by the president and then confirmed by the Senate. The Senate's role is to give advice and consent. This got very sticky a few years ago when, in the end of, it was the final year of President Obama's term, he appointed Merrick Garland to the Supreme Court. I think there were like 10 months left in the final year. And this, I'm going to share a little bit of this with you. Let me make sure I get the right time here. This is our former senator, Senator Hatch, who for a long time was the chair of the Senate Judiciary Committee, on the process of advice and consent. Let me pull this up here.
Like that. Well, I'm glad to be with you for a few minutes today. I served with Senator Kennedy on the Judiciary Committee for 32 years. In fact, he's the only senator who has served on the committee longer than I have. I know this makes me sound older than I am, but half of all life-tenured federal judges have been appointed since I joined the Judiciary Committee. The judiciary appointment process is an example of how America's founders sought to limit government power by dividing it. The president has the power to nominate, but cannot appoint without the advice and consent of the Senate. And debate continues about how robust or assertive the Senate's role should be. 3 significant events, occurred in the Judiciary Committee on January 1979. Senator Kennedy became chairman. Senator Leahy joined the committee, and the first hearing of the 96th Congress focused on the selection and confirmation of federal judges. This ongoing issue is obviously front and center today following the death of Antonin Scalia. The Kennedy Institute's poll earlier this year found that only 36% of Americans know that the Senate has a role, or has the role, of advice and consent in the appointment of Supreme Court justices. Raising that awareness, however, will do little good if Americans are aware of, but misunderstand, the Senate role. Using the Scalia vacancy as an example, I want to make 3 brief points. First, the Constitution gives the Senate the power of advice and consent, but does not specify how the Senate ought to exercise that power. Claims that the Constitution dictates when and how the confirmation process must occur, such as the immediate committee hearings, or as immediate committee hearings and timely floor votes are false. In fact, the Judiciary Committee was not created until 29 years after the Constitution was drafted. Second, the Senate has conducted the confirmation process in different ways at different times under different circumstances. The Judiciary Committee held its first public hearing on a Supreme Court nomination in 1916, but the nominee did not appear. The regular practice of nominees appearing publicly before the committee did not begin until the 1950s. Earl Warren, for example, did not appear at his 1954 confirmation hearing to be Chief Justice of the United States. In a 2014 report, the Congressional Research Service said this, quote, "Neither the Judiciary Committee nor the full Senate is compelled to act on nominations which come before it," unquote. Our former distinguished colleague, Robert Byrd, made the same point in a 2006 speech when he said, quote, "There is no stipulation in the Constitution as to how the Senate is to express its advice or give its consent. The Senate can refuse to confirm a nominee simply by saying nothing and doing nothing," unquote. Now, that is why the Senate has a standing rule providing that nominations that are neither approved nor rejected are returned to the president at the end of the two-year Congress. Nearly 1/4 of all Supreme Court nominations were never confirmed. Nearly 1/4. Another CRS report identified nearly a dozen different scenarios for how these nominations were handled. Some were referred to the Judiciary Committee, but never reported to the full Senate. Some came before the full Senate, but were never considered at all. As a simple matter of historical precedent, the Senate has never confirmed a Supreme Court nominee to a vacancy occurring this late in a president's tenure.
But they will. Let's just talk about that for a second, because here's why it's relevant, at least in modern times. I mean, it's relevant in general, because this is the process whereby we put judges on the bench, and they, of course, create the common law, which is a huge portion of the law that governs everything we do. So Justice Scalia dies in the beginning of the final year of President Obama's term. He appoints Merrick Garland. They never give him a hearing because, as Senator Hatch pointed out in the end of that discussion, because they had never, this was the answer that he gave, because they had never given a hearing to or acted on the nomination of a justice in the final year of a president's term. Fast forward, so President Trump takes office, and Neil Gorsuch winds up being the nominee from President Trump, who winds up filling Scalia's seat. At the end of President Trump's first term, Ruth Bader Ginsburg dies. So this is months before the election. He appoints Amy Coney Barrett like 4 weeks before the election. She gets a hearing, and she's approved within, was it a week? Let's see if I wrote that down in my notes. 1 week. She was confirmed in a party line vote 1 week before the 2020 presidential election. So Senator Hatch and I had a great deal of respect for Senator Hatch. I interviewed him many times over the years, and he was a lovely man. But he and I disagreed on this point. Nobody cares about my opinion on this, but because he and so many other Republicans had said after the Merrick Garland nomination that we don't consider a nominee in the final year of a president's term, when President Trump put Amy Coney Barrett up with a month to go and they voted on her the week before, suddenly that argument that, look, we need to give the people a chance to vote on this. If they want to put President Trump back in office, then he can move forward with Amy Coney Barrett. But if they choose someone else for president, that person would want to fill that vacancy with someone of their own choosing, and they ought to be. That argument went out the window because now it became an entirely political animal. And they admitted as much. They said, if the House and the Senate are controlled by the same party as in the White House, we don't have to do anything. So here's the second question I want you to answer in the discussion this week is, do you think that anything should be changed in the way that the Senate performs its advice and consent? Do you think that the Senate should pass rules or Congress should pass a law that requires them to hold a hearing and take a vote on any nominee for the federal bench from a presidency? Because when the opposing party is controlling the Senate, they'll let judicial nominations just sit there. And so vacancies won't be filled. And the legal, machinery of the federal courts comes to a grinding halt. And it'll take, your case that might have been able to be determined in a year will take 5 years. at the court level, at the district court level, because there just aren't enough judges and the workload is extreme. So it has a profound effect on Americans all over the country when those judgeships aren't filled. And certainly the most obvious and the biggest effect when the Supreme Court nominee isn't heard. And when I ask, do you think they should change the rules in this way? Should they be required to vote in a timely manner on any nominee? They can vote down. They can say, thumbs down. Don't want that guy or that woman. We don't want that lawyer. But should they be required to act, if only to remove at least a little bit of the politics from controlling? Because, remember, the third branch, the judicial branch, is supposed to be apolitical. We know that they're appointing, the process of appointing them is very political, but that branch, once they get on the bench, they are supposed to be as apolitical as possible. Would it benefit the nation to require the Senate to perform in a certain way, or should we allow them to continue to, exercise advice and consent in whatever way they see fit? And I think that we mentioned there that federal judges were appointed for life. So yeah, that's another question for you to take a look at. All right, we're coming down the home stretch for this particular lesson. So we talked about federal courts, state courts. Most people are in state court. Federal court is a more unique situation. The lower courts, there are actually courts below the trial court level in the state. So you've heard of small claims court or traffic court. These are courts of limited jurisdiction. And in fact, the magistrates that sit on these benches don't even have to be lawyers, at least in the state of Utah. They don't have to be lawyers. They can be appointed by, someone in the executive branch without a legal education necessarily. They're resolving very small disputes. If you lose there, then you go to the trial court where the person is absolutely a lawyer. And then there's 1 or 2 levels of appellate court. For many years, when I was first in law school, we did not have a court of appeals in the state of Utah. If you wanted to appeal the decision from the trial court, you had to go to the Utah Supreme Court. But now we have, as most states do, an appellate court. So the phrase judicial review refers to the right of any court to decide that a law cannot be enforced because it violates the Constitution. But there is a value, an ethic, a belief in the judges that if there are 2 or more ways to interpret a statute, the court should interpret it in the way that shows deference to the legislature. So if there are 2 different ways to interpret it, one of them finds it's constitutional, one finds it's unconstitutional, they will often tip the scales on the side of it being constitutional. They want to give deference to the legislature and their lawmaking authority if they can. So that's just something to keep in mind too. There are civil cases and criminal cases, as we've discussed vaguely. Let's focus on that a little bit more. In a civil case, it's one person suing another person. The person who brings the lawsuit is called the plaintiff. The person defending is the defendant. That makes sense. The person who brings the lawsuit files what's called a complaint with the court. That's a pleading. All papers filed with the court are called pleadings. So we file a complaint, you file an answer, you file a motion. All of these are filed before the court. These are pleadings. The motion to dismiss is a common motion filed by all defendants that basically says, look, even if everything he says is true, I'm not liable because the law is on my side. So, Your Honor, you have to dismiss this case because he could put on the best case imaginable and I'm still not liable because I didn't break the law or I didn't violate whatever liability he thinks I should. So that's the common motion that every defendant files. A motion for summary judgment is very similar in that it asks the court to make the decision, but it can be filed by either party. The defendant can file a motion for summary judgment and the plaintiff can also file a motion for summary judgment. In fact, I remember a case I worked on once where we had dueling motions for summary judgment. We were both saying to the court that the facts are not in dispute. There's nothing that's going to be learned at trial from witness testimony or expert testimony. There's no physical evidence. You know everything there is to know. You just have to decide which way the law applies. That's a motion for summary judgment. Judges will tend to not grant those motions if there's any fact in dispute. There's a fact in dispute, then that's a question for a jury. Juries resolve factual issues. That's their job. I was surprised when I was a lawyer how much time we spent fighting over jury instructions. That we would give a list of jury instructions. We'd write, and we had, in our computers, we had a database of instructions on all kinds of things. So we didn't have to write them from scratch every time, but we would tweak each jury instruction a little bit to try and make it as favorable to our client while still just stating the law. And then we'd give those jury instructions to the judge, proposed jury instructions. Our opponent would do the same thing. Occasionally, the judge would adopt one or the other of our proposed jury instructions, and that could have because words matter, right? I mean, words it's like the way a poll is phrased can have an effect on the outcome of the poll. And sometimes the judge would just use his own instructions or her own instructions. But that was something we fought over more than I anticipated when I was a law student. The standard to win at the trial court level and in a civil case is preponderance of the evidence. So I have to, if I'm the plaintiff, I have to establish by a preponderance of the evidence that you are liable. That means more than 50%. It's more than half. It's not the highest standard. It's not beyond a reasonable doubt. That's for criminal cases. It's a preponderance of the evidence. When we look at all the evidence, more than half looks like you're liable, then you're liable, and you can appeal. In a criminal case, the process is very different. In the federal level, there's always a grand jury. Many states use a grand jury too. We don't happen to use grand juries in our state system here in the state of Utah. We do for federal court. But a grand jury is really just another step in the indictment process. So if you have a grand jury, what the prosecutor does is they put together the evidence. They think they have a case against someone. And then they take that evidence and they present it to the grand jury. And then the grand jury returns an indictment. And then the criminal case proceeds. In our state criminal system, the prosecutor just brings the charge. He files an information. The information is an indictment. It's like the criminal version of the complaint. It states the facts, and then it makes the argument for what laws were violated. So it lays out the case in the information. Similarly, the indictment does that. In my opinion, the grand jury is, in most cases, not a necessary step because there's this sort of funny and also dismissive, and I apologize for the dismissiveness of this quote that's famous, that you can get a grand jury to indict a ham sandwich. That comes from the process of the grand jury. The grand jury does not allow the defense counsel to be present or the defendant. The grand jury only hears from the prosecutor and the prosecutor's witnesses. So the grand jury only hears one side of the case. None of the evidence is challenged. None of the testimony is challenged. So yeah, if you're only hearing one side of the case, you're probably going to indict. There are times when I think, especially if it's in a jurisdiction where a grand jury is available but not required, I think that why would that prosecutor take that case to a grand jury to get an indictment when he could just file an information? Probably because he wants to distance himself from the decision. He wants to be able to show, look, I didn't make the decision. The grand jury made the decision. I presented them with the evidence. They indicted. So that helps, especially if you're indicting somebody famous or somebody in power. Yeah, I didn't mean to indict the governor. It was the grand jury. It feels like a pass the buck sort of thing, but in any event, that is a part of the process. And we have a grand jury in the federal system that's required here in the state of Utah. The arraignment is the first appearance of a defendant before the court. They'll enter a plea at the arraignment. The preliminary hearing is the next step. That is sometimes waived by a defendant. When I was working at the public defender's office, we didn't waive preliminary hearings if we could help it, because you want to see what the prosecutor's case is. And that's where you get to see it. Now, they're required to share information with you, but the way you really get to see their case is at a preliminary hearing. And the only thing that's at issue before the jury isn't there at a preliminary hearing. The judge decides, is there sufficient evidence to carry this case over to trial? So if you're trying to get the case dismissed, if you have a legit chance at that, you might be able to convince the judge at the preliminary hearing stage, there's not a factual basis for this case. You should kick it out right now. This should not go to a jury. Rarely does that happen. Mostly you use the preliminary hearing to understand the strength of the prosecutor's case. And of course, the standard for conviction is beyond a reasonable doubt. Beyond a reasonable doubt does not mean 100%. What is reasonable? What kind of a doubt is reasonable? You know, this has been debated over the ages, and there is a lot of case law that talks about this, that when is the doubt reasonable? Yeah, I could go off on a real tangent here, but I will spare you that. Okay, that is the end of this first lesson for media law. Please respond to questions in the discussion portion of this module. I'll be doing similar lectures with slides for all of the different modules, and you can respond similarly in the discussion question area. Also, if you have any questions about anything that I reviewed today, please ask me. You can send me a message in Canvas. I'm glad to respond to you one-on-one, or I'm glad to do an additional video and post it with a deeper explanation that can be shared with everyone. Hope you enjoy the readings. I know that legal readings can be a little dry, just wading through cases. That's why I try and bring them to life as much as possible. As we get into more of the case law next time, you'll see that so many of these fights are really interesting. And it's easier to remember the cases based on the facts of what happened than on their names specifically. All right, let me know if you have any questions, and I'll see you next time. Thanks, everybody.